Welcome, everyone, to another episode of the Lifetime Legacy Lawyer podcast. My name is Thomas Vick of Vick Law PC. I'm joined by Seth Wilson of Adler Attorneys, and we're ready for another episode talking about issues related to estate planning and estate administration. Seth, how are you today?
Hey, Thomas, I'm doing well. It's good to see you on this opening weekend of the March festivities.
Yes,
I don't think we can say certain things because of the licensing issues surrounding those number of basketball games that happen this time of year, but it's always a fun time of year.
absolutely. Definitely very enjoyable time of year for me. And um, I was telling you before we started here that the first Thursday on a particular week in March, we call it St. Naismith's Day in
There
honor
you go.
of James Naismith, the inventor of the game of basketball. People in Indiana have much owed to James Naismith and the enjoyment we get from the game of basketball. So,
But that's right. That's right. That's a lot of fun. So it's a good time of year. We always have a lot of fun in my household, and the sheer number of games and things. So it's fun to try to keep up with that. And, it makes you think about the family traditions and legacy that is there. And, part of the fun of what we get to do with folks is help them plan for that so they can enjoy these moments without having these issues weighing on their minds. So I thought today maybe we could kind of go through what are some of the basic peace of mind documents that you need in your estate plan.
yeah, there are certain documents that everybody should have in his or her estate plan. The first one to consider is a will, which your will is, the governing document that tells, where your assets are to go. If you don't have any other way of distributing assets, your will controls, and it tells the court and your personal representative who ultimately is to get your property. And so it serves that purpose, but then it also serves the purpose of naming a guardian if parents who execute a will name it, and they have minor children. You can name a guardian of your minor children in the will. If you and the other parent were to pass away, the guardian that you nominate could be appointed by a court based upon your recommendation in the will. So it serves those two principal purposes. There are other things that go into it, but certainly a will is needed for everyone. What's the next one that you have?
Well, let me just piggyback on that for just a second and transition, if you don't mind. But the lack of a will leaves you in an intestate situation, and so that just means that the state law then governs what happens to your assets and or what might happen to any minor children that you're responsible for in the absence of having that documentation in place. So even as a younger family, it's often a good idea to have a will in place, even if you're not as concerned about, well, I don't have a ton of assets to move at the appropriate time. You don't want to be in a situation where your plan is not being carried out because you didn't document what you would like to have happen. And so that kind of leads into the next document, which is a trust. And that trust document is really something that helps manage the assets and your financial estate, if you will, during life. And you can title different types of assets into a trust. And the theory being, as you've done that, then you don't have any assets in your individual name. The trust owns them, and therefore probate may not be required at the appropriate time. And so there's different types of that, and they're a little bit more complicated in the front end to set up, but can really avoid some problems, not really problems, I guess, but some more process, if you will, at the tail end of life. So that's kind of what I tell my clients is if you're doing the trust preparation now, it's almost like you're doing probate at this time of life and really making it as easy as possible for the successive generations.
Yeah, and I may or may not have stolen that phrase when talking to clients from you, Seth. Getting probate done ahead of time while you're living. I think that makes a whole lot of sense when we're talking about revocable living trusts. And one thing related to what I was saying about naming guardians of minor children, guardians can be guardians of the person and or of the estate. And you don't want to have court involvement in a guardianship of the estate. If you can avoid it, let somebody else rather than a court, manage the funds of a minor through a trust, and that way it's less burdensome on the person that's taking care of the minor children. So that's one thing to keep in mind with a trust. Um, what about what is a trustee, Seth? What could you say about that term trustee? We've used it several times, but what is a trustee?
Yeah, so a trustee is just that, someone that you trust to handle things for you. And typically you're talking about financial kind of determinations, as opposed to maybe a guardian who has a responsibility for a minor child or incapacitated child. But the trustee can serve that role as well if you're a married couple and your spouse has a condition or situation where he or she is unable to manage their own affairs at that time. The other trustee can continue to operate within the bounds of the trust and the rules that are set up there to manage those funds. The trustee is also a fiduciary role, most typically, because they are responsible to step into the shoes of the individual and act in their best interest. Again, according to the terms of that trust, however those rules for playing the game are set up. So that trustee is a very important person. It implies that it needs to be someone that you do trust to handle things, but effectively that person is charged with carrying out the terms of the trust.
Very good, very good. Um, and then there are different kinds of trusts. The most common one that we deal with is a revocable trust. So that's usually where a client comes into the office and the client ends up being the trustee of their own revocable trust, and the client is able to make changes to the trust throughout their lifetime, put assets into the trust at any time, take assets out, make any amendments, can cancel the trust at all, at any point. So it's really just kind of putting it into, a treasure chest, if you will, setting it aside, but you're in charge of opening and closing that treasure chest, if you will. So that's a living trust, and we've already mentioned it avoids probate, but then it has benefits, especially for the beneficiaries. It can plan for the contingencies that may arise that we can't necessarily see at this point in time. If a child were to become disabled, well, it can plan for taking care of that child and making sure that they have the government benefits that they otherwise would be entitled to. It's got some spendthrift protections in it and things of that nature to help with creditors. And so those are some aspects to living trusts that are advantageous to clients.
Yeah, and they work hand in glove with kind of the next document that you need in a full estate plan, which is a power of attorney. Because there are certain times that the trustee may need to act as a power of attorney for someone else, and you may not want to use the whole trust powers to do a real estate deal if you can use the power of attorney to do that. But those two documents work very well together. And there may be, I see this a lot in my practice, we don't want to move, maybe the client owns a business and they've got it set up in a certain way that it doesn't really make sense to bring that ownership back into the trust, but it's handled by its own operating agreement or shareholder agreements or whatever may be in place, so that the power of attorney can sort of bridge that gap if the disabled spouse needs the other spouse to step in and help manage the business for a time during an incapacity. Again, a little more complication there because you have an operating agreement potentially if it's an LLC or some sort of shareholder agreement and those kind of things. But that power of attorney gives the authority for someone to act on your behalf. in a specified way. And I often tell my clients the powers of attorney have gotten a lot longer over the years since I've practiced, because they're really sort of setting out the ground rules for what the power of attorney is able to do in your stead. And so when that's taken to a bank, for example, the bank can look at a specific provision of that power of attorney and say, okay, you're authorized to do that. I see that it's listed right here. So it's a very good instruction book as to what can be done and also what cannot be done by the power of attorney.
Yeah, and that's a good point that you make about how the power of attorney serves a different purpose than the trust. And there can be a lot of overlap in the power of attorney document and the trust document, but they're different. And sometimes things are not titled in the name of the trust, and maybe you're not even, legally allowed to put something into a trust, like a business interest or something like that. And so having a power of attorney is essential so that somebody else can step into the shoes of someone who is incapacitated. So that, good stuff on that one. And then the last one is an advanced healthcare directive, and that's a document that will authorize an individual to make decisions upon the behalf of somebody else. If they're not able to make healthcare decisions, somebody else can make those healthcare decisions, and we see that that's important. We've talked about guardianship quite a bit, but there can be a requirement of a guardianship if of an adult, if and unfortunately sometimes a spouse has to go and get guardianship of the other spouse because there's not a healthcare advance directive, which is just a kind of a tragic situation where you're actually having to ask a court for permission to take care of somebody that you've lived with for 30, 40, 50 years. And so that's why we always encourage, get a healthcare advance directive in place so that you're not going to be faced with that kind of situation.
Yeah, agreed. And it's definitely something you need to do at a time when everybody is of sound mind and able to make these decisions on their own behalf. And if you wait till it gets a little bit closer to time, or a situation has progressed to where there's some competency questions, that's a really challenging position to be in, because you're really crossing a line between where the advanced healthcare directive can be effective and where you may need the court to actually issue or appoint a guardian over the person and property of that individual because of health conditions. So it's a touchy situation, the closer you get to it being necessary. So again, if you can get that in place ahead of time, always a good thing to have, and being prepared for that contingency.
Yeah. We had a couple other topics in the email that went out with the blog digest today. The next one was, what should I know about funeral planning? That's what a wonderful topic to discuss on a Friday morning. But there are some things that we should know about funeral planning.
Yeah, and I think how I typically explain this is, you can think about it as little or as much as you want. And some folks really want to have things planned out because they feel like that's alleviating the burden on their loved ones, who in that moment will have some more of the logistical things to take care of. And so if there's a plan left by mom or dad that really details the service and where the burial plots are and those kind of things, that can be really helpful. And so you may fall on that end of the continuum, or you may fall on the other end where I don't want to think about or do anything about this. And I think either position is fine, or anywhere along the chain. But legally speaking, I don't actually often advise, could be in the right situation, that someone have a true funeral planning declaration that they want to be carried out to the T. Usually say it's more of an outline or a checklist to, here are some things to consider. Here's what you could do, and you can make it binding, but most of the time, I think most clients are looking for some more guidance and maybe getting that structure in place, things to think about, or steps that they can take in terms of, maybe we go ahead and get the funeral plot or prepay for certain things. as part of that. And obviously that sort of intersects with some of the advanced Medicaid planning that can be done in terms of that. So how do you handle that discussion on that end?
Right. So in advising Medicaid clients, we're often looking at what are some ways that we can spend down our assets down to the resource limit of $2,000, well, in the most advantageous way. And one of the advantageous ways of spending down is going ahead and paying for things that you know that you're going to need. And one of those big expenses is a funeral. You know, they can range from, you know, all kinds of prices, but you know, it's pretty common to see $7,000 to $10,000 of funeral expenses. And in Medicaid situations, you know, that's a great way of spending down. There are a couple things that you got to keep in mind with that. You know, when you purchase a prepaid funeral, the prepaid funeral is revocable for 30 days. So after you purchase it, if you change your mind, you can get your money back within 30 days. But in Medicaid situations, we often don't want to wait that 30 days. We want to get that money that's been paid off the books. So you've got to check a couple boxes on the prepaid funeral form so that, you know, it's a Medicaid compliant prepaid funeral plan. So that's one thing that I talk to clients about, making sure that when you do the prepaid funeral, you do so in a Medicaid compliant manner. And when you do that, you know, that'll assist you in gaining Medicaid eligibility.
Yeah. And I think some of the points in the blog digest were very well taken, in that there is an element of added stress and grief component when you have to go and sort of start from scratch if you are the loved one responsible for carrying out the funeral planning after someone passes on. And so if you can think ahead a little bit of, these are the contacts that we've used, or these are the funeral homes that we're comfortable with, or you know, some level of detail can really help that process. Perhaps one thing I would suggest is, if you are in a funeral and you thought whatever element of that funeral was appropriate, or you liked how that plan worked, make a note of that in your own documents for your kids. I liked how, you know, grandma did this at her funeral, and I thought that might be a good thing to carry on and work through. So it's good to kind of be observant of that as time goes on, and take what you've learned over the years and enjoyed or appreciated as part of someone else's service, and incorporate that into your own as the time goes on. And then have those conversations with your loved ones. That's not a fun topic to talk about, of course, but hey, you know, if we're a family and we're all at a funeral of another family member, sometimes that's just a good time to say, hey, we like these elements of the funeral, and I, you know, when the time comes for one of us, let's keep that in mind.
Yeah.
So I think probably enough on that topic. Moving on to, you know, it's kind of interesting the way that your digest was set up today. Is kind of felt like a pathway to kind of these big emotional issues that show up in estate planning. I think we talked a couple weeks ago about how it can be difficult in these transitionary times to deal with the emotional issues that are coming up, and how those emotional issues can often impact your decision making and how you plan and think in those moments. So I thought that was a good capstone piece for this week of, hey, you need to just be aware of that, and then here's some ideas for how to adjust it. So what were your thoughts?
Right. So a couple components to that last blog post. You've got legacy planning and you've got family issues. Um, you know, and the client is usually in the best position to kind of tell the attorney what the issues are, and then the attorney can kind of help and plan for, well, this is what you can do. And you know, a lot of times, you know, there may be an adult child that unfortunately, the client doesn't trust. Um, but the client wants to provide for that kid's that kid's kids, grandkids through that child. And so you talk to them about, well, you can maybe avoid that child and still take care of your grandkids through that child by setting up a trust and naming somebody that you do trust as trustee for that, and navigating that emotional issue. You feel like you're not, there's a path forward for you that kind of respects the concern of the client, but then accomplishes the purposes of the client. So it's really a family to family basis. There, that's where kind of you have to customize the estate plan to fit the client's needs. But and one of those things is, I don't want, even if it's a child that I trust, I don't want the child to receive everything when they're 25 years old or when they're 30 years old. Maybe you want to spread that out. Maybe you want to put some stipulations on it. You got to get an education first. Maybe you want to say you can use this money to start a business, or this is how the business is to be bought out, and these people have a right to purchase, that kind of stuff. All those things go into it. And so having conversations with the client and understanding who are the players involved, what are the emotional issues that are a part of this discussion, and then the attorney can help navigate through that.
Yeah. And I think it's helpful from an attorney perspective, as you've gotten experience in life, or in my case, I've done a lot of litigation over the years for various types of cases, and learning how that affects people helps inform how I ask questions about sort of the second level discussion beyond just, hey, I want to give my assets to these folks, depending on the type of asset and whether it's sort of a sentimental thing, or is it have some sort of monetary value that can be assessed to it. And what if there's only one of a certain item, how is that going to be addressed, in that you might have three people interested in that? How do you want to address those emotional sentimental concerns around something, and try to make sure that we're addressing those? And obviously we can't go that in detail, or we would maybe potentially spend most of our life planning out somebody else's life, right? And so there's ways around some of those things, but being aware of some of those bigger picture concerns and helping the client think that through, that what is being done now obviously is going to come into play at a time in the future, and we want to make sure that that's as peaceful as it can be at that time.
For sure, for sure. Well, I think that wraps up another episode of Lifetime Legacy Lawyer. Seth, tell everybody where we can find you.
I appreciate it, Thomas. We are here in the heart of Hamilton County in Noblesville, Indiana, and you can find our contact information on the website, noblesvilleattorney.com. How about yourself, Thomas?
And I am Thomas Vick of Vick Law PC. You can find us by going online to vicklaw.org. As always, Seth, appreciate it. We'll see you next time.
Sounds good. Thanks, Thomas.